For me, for me, a theoretical framework is obviously if you're conducting research, you have to use a specific framework, let's say a theory, in which you say, are universal human rights applicable to every human being? Within that, you will then look at 4 or 5 keywords, for example, universal human rights, equal rights, women's rights, minority rights, and for example, cultural relativism, which is kind of an opposite of universal human rights, because according to the theoretical framework of universal human rights apply to everybody. Whereas cultural relativists say that even though you might have universal human rights or human rights for everybody, they are still influenced by culture. So if we go back to the number on women's rights, which is one of the 4 or 5 key words, according to universal human rights, women's rights and equal rights are complementary to one another, and they should apply to every woman in the world equally. Whereas a cultural relativist would say, let's say from Saudi Arabia, they would say that culture influences those human rights, which basically entails that women's rights, they might have women's rights, but they're still influenced by culture. In Saudi Arabia, that means the Islam, fatwas and all that, so that would ultimately lead to women's rights having less rights, or at least being influenced by culture, and that obviously derogates from that, right? Anywho, operationalization, measurement, and breaking down of these key words. If you look at universal rights, I basically already said, universal rights are those human rights that are applicable to everybody. If you look at it from women's rights, minority rights, and equal rights, they're basically all linked to the same thing, which entails that from an operationalization or measurement point of view, that if you analyze within your theoretical framework whether or not they're applicable, you would have to analyze, let's say, a country situation or a specific situation. You have to look at the laws and legislation of a country, the practical effect thereof vis-a-vis women. And then you can say, well, operationalization-wise, in Holland, women's rights are codified by the Constitution, which basically entails that women's rights are protected. If a woman feels like her rights are being violated in Holland, they can go to a court of law and say, hey, the state or this company are violating my human rights. For example, here in Mexico, sometimes it happens that women, for example, apply, they're basically pregnant and they don't get a job. They basically don't get a job because they're pregnant, and the employer thinks, well, I'm not going to give her a job because she's going to leave after a while. You can say that's a specific aspect of a woman, right? Now, technically speaking, the law says you're not allowed to discriminate, so then the woman can go to a court and basically have her violation or possible violation tested by a competent court. That's the rule of law, right? So in that sense, you can generally, the whole idea of operationalization, measurement, and breaking down of these keywords is that you have keywords, you have the theoretical approaches to it, so universalism and cultural relativism, and then you can basically apply this framework to different countries. Generally what you do, at least from a legal human rights point of view, is check what are the laws at the international level that stipulate what are human rights. Then you go down to the national level. Then you say, what are the laws and legislations in operation that basically stipulate and provide your legal framework of protection based upon that international dimension, right? And if you want to measure it, you can look at actual case law, practice of government officials, businesses, whatever it is. And whenever there's a possible violation, you look at the jurisprudence. That's what lawyers do, or a legal analyst. Okay, so you have the theory, you have the practical application at the national level of that theory or those theoretical approaches from the international level, and you generally tend to test that either by jurisprudence, country reports, etc., etc. Which theories do I generally utilize, especially in the field of human rights? I already mentioned that. It's basically the universal human rights approach versus the cultural relativism human rights approach. Again, universal human rights, the proponents thereof basically say human rights are for everybody, they're universal, they should be equally applied. Cultural relativists look at how culture can influence the enjoyment of human rights. Which investigation methods have you used and why? I generally always focus on, again, you have the conventions, the laws, all that at the international level. If Mexico becomes a state party to a human rights convention, then what you do is basically look at the rights and duties that arise from the international level and how that is implemented at the national level. Based on that, you can create a comparative analysis between the international and the national. You check what the laws say, in both in theory as well as in practice. You generally would add jurisprudence to that. The jurisprudence can be at the national level, let's say for Mexico, regular court up to the Supreme Court. Sometimes you will have cases at the regional level. For example, the Inter-American Court of Human Rights also has a lot of treaties and jurisprudence. And you can obviously look at the international level, and that is generally the United Nations system. So, particularly in the field of human rights, obviously the Office of the High Commissioner for Human Rights. And within that, you have, let's say, the ICCPR, which is civil and political rights, the ICESCR, which is economic, social, cultural rights, etc., etc. You have the CAT, which is the Convention Against Torture, etc., etc. So you have like 10, 20 fundamental conventions at the international level. Mexico is basically a state party to all of those. So all of those 20 conventions, give or take 20, 15, whatever, have to be transformed into Mexican law and legislation, right? And then you can basically, depending on what you're investigating, so again, let's say women's rights, you have, for example, the CEDAW, CEDAW, which stands for Convention with the Elimination of All Forms of Discrimination Against Women, which basically provides for all kinds of different rights and duties that a state has, both positive and negative, to respect enjoyment of women's rights by women, obviously. And again, if anything is wrong, you look at the jurisprudence, you look at the laws, it can be at the national, regional, or international level. Have you used some kind of research software for investigation? I'm not entirely sure what you mean by research software, but what I generally use are databases from different organizations, etc. Generally speaking, every, let's say the CEDAW, so this Women's Rights Convention, has their own specific page, and there they have, for example, the convention, they have general comments, they have jurisprudence, they have country reports, etc. So the kind of research software, I mean, it's not like statistical software per se, but it's more like databases, resolutions, jurisprudence, etc. So it's not pure statistical data per se, but it has to do much more with databases of legal conventions, resolutions, etc. Anywho, last one, what's the relation between method and theory? The theory is our theoretical approaches, propositions of different ideas that you say. Generally, the methodology you use is meant to prove or disprove your theory. So if I would say, I don't know, women's rights are universal and the right to equal payment by Mexican authorities should be applicable. That's, let's say, kind of your theoretical framework of approach, right? Women's rights, universal. What you then do is test that theory by using methodology. For example, what does Mexican law or practice say about the enjoyment of equal rights by women? And then you basically test that theory by using methods. And in the case of, generally speaking, of human rights or international law, the methodology is to test it by analyzing the laws and practices, both at the national and the international level, create a comparative analysis of those two, and see whether or not the national focuses and follows the international. If that is not the case, you basically have to ask, why is that? Can you say that that is a cultural point of view? Can you say that that is more of a practical point of view in which the government authorities do not respect the women's rights of of women, obviously, and whether why is that? And then you have to find out that, generally speaking, either through country reports, jurisprudence, laws, practice, statements, etc. Okay, let me know if this is enough. Bye bye.